morning and welcome to Legal Sessions. My name is Emil Cordova and today we'll be talking about the subject of divorce. As of 2007, Florida's divorce rate was 4.6 per 1,000 people, and for many, probably the most difficult times of their lives. To talk about the subject today, we have brought to our program attorneys Ashley Tennyson and Christina Soberon-George, both from the firm Tennyson and Soberon-George. Good morning, ladies, and welcome. What is the actual process for someone that would like to file for divorce in Florida?
Good morning, Emil. In Florida, divorce is known as dissolution of marriage, and Florida is a no-fault state. What this means is that when you file for divorce, you just have to state that the marriage is irretrievably broken. And this is helpful because divorce is already a very emotional process for people. And so when you can just say that you have now irreconcilable differences, you're not upsetting the other party by citing specific reasons or going into behaviors that have made you want to file for divorce.
Ashley, is the process as simple as it sounds? What about property distribution, child custody, and support? How is all that handled?
Well, Emil, as we probably know, divorce is rarely ever simple. Unfortunately, there are many factors that must be gone through and determined before the court will order a final dissolution of marriage, a divorce. One of the factors that must be decided by the parties is how the property will be distributed. When I talk about this, in Florida, what we call it is equitable distribution of the property. And the property we're referring to is marital property, the property that both couples have contributed during the course of their marriage. Now, in Florida, the courts want both parties to try to establish a settlement on how they will divide their own property. And if they can't reach this agreement or a settlement, then the courts step in and try to divide it as equally as possible.
Another factor is time sharing. Now, what courts try to do is encourage both parents to come up with a time sharing plan that they can agree on. However, not everybody agrees. And so when this happens, the court will step in and develop a time sharing plan that allows both parents to have time with the child, unless the court finds that that would be detrimental to the child. And the other factor is child support. Now, under Florida law, both parents are required to support the child until the child reaches the age of 18. And what the Department of Revenue has done is they've set up this program called the Child Support Enforcement Program. And that's exactly what it sounds like. They're there to support child support orders and make sure that those things are enforced. And when one parent isn't making the payments, they will step in and take the necessary actions.
Obviously, there's quite a bit more to divorce than we have time to cover in our program today. Therefore, if you have any questions or would like to schedule a consultation, feel free to contact attorney Tennyson and Soberon-George at 407-412-7040, or you can always visit their website, TSLDefense.com. Ladies, thank you for your insight into our subject today, and we look forward to having you again in our program.